All rise. Supreme Court of Guam Sound session. The Honorable Chief Justice Robert J. Torres presiding. Be seated.
Alphadan, good morning. Will the clerk please call the case?
This is Supreme Court case number CVA22-003, RSA-Tumon, LLC, Plaintiff Appellee versus Pitt County Memorial Hospital, Inc., Defendant Appellee, and Sharif A. Phillips, Defendant Appellant. Appearing for the Defendant Appellant is Sharif Antoon Phillips, MD Pro Se. Appearing for the Plaintiff Appellee are Attorney Anita Pierola and Attorney William B. Brennan. Appearing for the Defendant Appellee is Attorney Daniel J. Berman. Apologies. Mr. Phillips reserves 15 minutes, and Mr. Brennan and Mr. Berman will split their time.
Thank you, Dr. Phillips. You may proceed. Before you start, Dr. Phillips, you have 30 minutes and you've reserved 15 minutes. You can use your time any way you want, but I do want to try to caution you that it is a short period of time, and I suggest that you focus on 3 issues. That one is the jurisdiction of the court. This is a judgment that is not a final judgment of the trial court, and you should address why the court should hear it as an interlocutory matter. Secondly, I think you should also look at the jurisdiction of the court, the trial court below, and the issues of subject matter jurisdiction and personal jurisdiction over you. And then third, on the why you feel the trial court abused its discretion in denying the motion to dismiss. The court is not interested in hearing about the North Carolina judgment and any infirmities that might have been encountered with the issuance of that judgment. It's not relevant to the proceedings before us today. So with that caution, you're free to proceed, Dr. Phillips.
Okay. Good morning, Your Honor. Defendant has never, in my case, never been a local matter. It was a default North Carolina judgment without any judicial assessment or trial on the merit of the action. North Carolina order.
Dr. Phillips, can you move a little closer to the mic? It's a little difficult to hear you.
Sorry, Your Honor. My case never been a local matter. It was a default North Carolina judgment without any judicial assessment or trial on the merit of the action. North Carolina order wasn't final, was a disputed legal fee where North Carolina regulation regarding the legal fee has never been followed. I filed for an undisputed claim of fraud upon the court. A decision produced for fraud by the court is not an a decision at all and never become final. We're talking first about, as you recommended, the subject matter jurisdiction, lack of personal jurisdiction over the defendant. If, according to the court's definition, it's the state of domicile is a state of the permanent address. And as recommended by the court, the permanent home address where the defendant intending to remain or to which he retained as a permanent address. My first permanent address was North Carolina, and now is Florida public record for almost 3 years. Since 1945, the Supreme Court had elaborated the nature and quality of the minimum contacts that the defendant must have for the court to subject him or her to personal jurisdiction in the forum consistent with the due process. A court exercise a specific jurisdiction may be constitutional when the defendant has contacts with the forum that give rise to or are related to the plaintiff cause of action.
Dr. Phillips, let's assume that you're not a resident of Guam, as you allege. The court found that you had been living and practicing in Guam, and that gave rise to jurisdiction because your activities were continuous and were systematic, and also the dispute in here related to, it was a reasonable exercise of jurisdiction and the dispute related to your interest in this entity that is doing business on Guam.
Here is a definition of unilateral activity in the forum state by a person. It will not be enough to establish, defend the minimum contact. This means some family, business, or other relation is not enough to establish the defend the minimum contact. And we have to focus on the location of the resulting injury to the plaintiff. The injury for the plaintiff never happened in Guam. That's why it is not recognized as continuous and systemic as a unilateral activity. That's recommended from the court.
But you do admit you're conducting activities in Guam, right?
It's a business, just a business, because I have no choice. When they terminate me, I have no choice. They fight me any other option to find any business anywhere. So
And isn't the claim here related to that business?
Not your honor. They destroy my career. They destroy my reputation. I try to find job anywhere. The only accepted for me is Guam. So I have no choice. That's why I left as a temporary, started as a locum tenant, temporary.
But this case is an attempt to get your interest in, an interpleader was filed to get your interest in the RSI entity here, right?
Not your honor. It is actually, that's why I'm telling you, when they promote me as a physician first, they try to work here. They offer me 5% as a promotion. But I started as a locum tenant, and all of my taxes filing and everything, I don't have no permanent address. Even my address in the clinic is not here.
But the claim here is focused on that 5%, right?
That's why when we focus about the 5%, the whole thing, that's why it is, the law has not been followed as prescribed. If we're looking for the statute of limitation of Rule 54 to be for the legal fee supposed to be filed within 2 weeks, and we have to know what's going on with why we enforcement all of this statement. But what we looking enforce a court order which followed by fraud upon the court, no basis whatsoever, not supported by any statute, not supported by any case of law, and we try to enforce it. That's why I try to approve to the court. The law has not been followed. Even if we look, I ask for Rule 54 to 54 54 B2. This week supposed to be filed within 2 weeks. The order for the legal fee and everything was done in 2014 and enforced in 2016 in North Carolina.
Again, Dr. Phillips, really the judgment in North Carolina is not what your appeal here is concerning. Your appeal is the appeal of the trial court's dismissal denial of your motion to dismiss the interpleader action that was filed regarding your 5% interest in the company.
Correct.
So we're not really addressing the North Carolina litigation.
Okay, so let me finish, Your Honor, about jurisdiction. If we're looking about lack of personal jurisdiction, my case already is a federal court case because I asked him for a due process and also for the 5th and 14th Amendment and follow the law as prescribed.
But the district court dismissed the case. I know you alleged that there was diversity of citizenship and it dismissed that case. And then you took an appeal and the Ninth Circuit also dismissed that case.
Let me explain all of this, what happened. Because the court was acting as a lawyer during the procedure. First of all, RSA is just a name. It's just a name. It's belonged to US Renal before or Fresenius Medical Company. And they said it's a Delaware limited company. When I transferred the claim for interpleader to the state court, they act as a lawyer. They enforce the PLLC corporate law and a state of domicile for both of us. Me and the defendant as the plaintiff, they are not interested in the state of domicile. The state of domicile never been addressed. The court added, but they neglected I'm defending valuable property for the 5%. So when I file for reconsideration as the Ninth Circuit, as the District Court first, the Ninth Circuit, sorry, they said because the remand is non-reviewable. I give him too many cases, it is reviewable. So they still denied. So when I filed for appeal for the reconsideration, I got a court order amendment from the Ninth Circuit that I have a chance for reconsideration, depending reconsideration for the remand motion, not for the state of domicile or jurisdiction. So they tell me one chance, and it was in unpublished memorandum. So I think it was vague for me in the way that I reconsideration the remand and motion, they said non-reviewable. Then when I asked for reconsideration, but they never look about the state of domicile or my federal jurisdiction.
Dr. Phillips, why are you filing these lawsuits? What's the purpose? What is your end goal that you're trying to accomplish?
Your Honor, I lost everything. I spent almost $3 million for legal fee to fight my private practice, what I did and everything. They molested me, and to understand the background of this case, basically to practice nephrology, you have to have Pitt County privilege because it is already the only one covers the whole East Coast for approved by Medicare for inpatient dialysis patient. After I've been practiced for almost 10 years, they suspended my privilege and take over my dialysis patient.
Although the Chief Justice said that this is a very limited
I understand.
case, but I'm trying to give you your day in court, and so I want to know, because your lawsuits are taking up a lot of time and resources of the judiciary. So is it your purpose to try and get out of paying the North Carolina judgment?
The pain, I understand that. I have been suffering. I spent all of my dues. They destroy my career. I start from scratch. I award them to us for the legal fee we are not entitled for. There is no support, any statute or any case of law across the board. It was a summary judgment motion. Is not allowed to have.
So what I'm understanding is that you feel that you don't owe this.
Exactly. I lost everything.
But that boat has sailed, and that judgment has been reduced to a local judgment here in our courts, and that's final. And so
it's never been final. If I file for a disputed fraud upon the court, it's never been final. How Pitt County Memorial has 2 years since 2016. Why they didn't enforce it in North Carolina? Why they take?
So you feel that by filing all these lawsuits and trying to attack it collaterally, that at some point there's going to be a court that's going to say you don't owe this money? Is that what you think?
I tried to, Your Honor. I lost everything. It's not worthwhile. After all of my legal expense, I lost it for non-professional review issues. They destroyed my career. I have been living in Guam away from my family. What kind of living? I living by myself without any support for anybody.
But I understand, but I'm just trying to, maybe I don't understand. What is the purpose of all these lawsuits?
I tried to get rid of all of this harm that they keep harming me for they destroy my career, and even they fighting.
Who is they? And
Pitt County Memorial. They report me to the data bank for non-professional nine that I very hard to get a job.
Do you know why Pitt County is continuing to pursue this action against you?
It was, if we're looking for the history, it's totally discriminatory because I'm foreign medical grad. This area this area really localized to the redneck people.
But all these lawsuits really come down to one point, and that is you have not paid a judgment that has been rendered final by the North Carolina courts and has been reduced
I
and
understand.
recognized as a
I
judgment.
understand, Your Honor. Your Honor, if you're looking, if they have a chance and they have a case and it was final, why it take him 2 years to file it in Guam? Why? And even the 54D.
So you feel that by filing these various objections that this.
Is some
that
sort of
this-
harassment?
Let me finish my question.
Sure.
That this judgment is in some way going to go away?
It's not go away, at least we stop all of the legal fee if they give up the legal fee. If they stop, I'm running in circle. I run out of resources. How are I going to pay him with interest for legal fees? They are not deserved.
All right. You may continue, but that, you know, this is a very limited case that's in front of us, the issues, and has to do with jurisdiction.
Okay, if you're looking,
But if we peel all that away, I just want to understand what is your end goal? What is it that you're trying to accomplish?
that's why I transfer everything to the 9th Circuit. This is a finale. This is a finale. That's why I try to consolidate and everything, and I go to the 9th Circuit to go through it. That's why I apply for the appeal after this court and everything.
But the 9th Circuit has dismissed your
No,
appeal.
no, I file another appeal for the, when I file a lawsuit against the Guam jurisdiction court.
Dr. Phillips, let me ask you, in this case, the trial court denied the motion to dismiss, your motion to dismiss. Normally, we do not take an appeal unless it's a final judgment, unless the case is all done. This case down below is not done yet, but yet you filed an appeal. Why should we hear this case now, this appeal now, instead of waiting until the case below is finished, until the court makes a final ruling on the disposition of the 5% interest, and then everything gets appealed at one time? Why should we do it piecemeal and address just this one motion? Because the court may make many motion decisions or decisions on motions that you file, and we can't have an appeal of every single decision that the court makes. Usually we wait until the case is over, until final judgment is entered. Why should we take this denial of the motion on appeal now?
Because 2 issues, it's lack of personal jurisdiction, as I explained. Second, the case have a federal question jurisdiction between the 14th Amendment and the 5th Amendment, and the law has not been followed as prescribed. Besides, when they discussed the interpleader, it was a side talk. I never been get involved with that. And I tried to approve RSA-Tumon LLC is just a name. It is running by the corporate law, and it's running by the shareholder. I don't own any shareholder for that. They holding my dividends for almost 3 years, and they report it as an income tax. Why, if we have this interpleader and everything like that, and even they run it without let me know, and we go for sale property and everything, this a due process, and this a private property. That's a question stuff. That's why she lack of jurisdiction. The issue for me, you proceed with default judgment and try to enforcement after the statute of limitation, and told me give it away, all of whatever I owe. That's why I have been working for almost my life for free. They take over all of my revenue. It doesn't make sense.
Your 15 minutes is up. You've used 17 plus minutes. So do you still want to reserve?
Yes, until we see what's there.
All right, thank you. Mr. Brennan, will you go first? And then I think Mr. Berman indicated at status, he'll just have a couple of minutes, right? All right, thank you.
That's
Mr. Brennan, you may proceed.
Thank you. If I could just have a minute. Mr. Chief Justice, and may it please the court. No final judgment has been entered in the court below. This court did not grant Dr. Phillips permission to seek interlocutory appellate relief in this matter. And no request for an extraordinary writ under Guam law is properly before this court. For these reasons, the court lacks jurisdiction. In this case, this appeal should be summarily denied and dismissed. If the court disagrees and reaches the merits of the Superior Court's February 15th, 2022 decision and order, the court should affirm. It's clear under Guam law that the Superior Court of Guam has subject matter jurisdiction to hear properly pleaded claims for interpleader and injunctive relief. And it's also clear in this case, and quite frankly, it's the law of the case, that Dr. Phillips is a resident of Guam, and at the time of service of the summons and complaint, the court acquired jurisdiction over him. Even if he were a non-resident, we think it's indisputable by his own admissions that the court could exercise general jurisdiction, the Superior Court, or specific jurisdiction, depending on which facts the court highlights in any decision.
Mr. Brennan, although the court has not granted the petition and for interlocutory appeal and has not converted his filing to a petition, what is to be accomplished, practically speaking, by the court denying this as converting it to a petition for an interlocutory appeal and going to the merits of the case? What's to be accomplished by the court denying the petition for interlocutory appeal?
A couple of things, Your Honor. I mean, interlocutory appeal before this court is discretionary, and this court has recognized that that discretion should only be exercised in limited circumstances. So you'd want to give some sort of regularity to the Superior
Well,
Court.
wouldn't this terminate, go to advancing the termination of the litigation if we were to grant the interlocutory appeal?
Not necessarily, Your Honor, and just
Why not?
to sort of exemplify the prejudice that our client would face in that situation is we weren't able to be heard on the factors that would inform this court why or why not an interlocutory appeal is appropriate. And when this court acts, it must do so deliberately. So if the court's going to open the door to other litigants to file these types of motions and just expect interlocutory appeal, I think then this court would be amending 7 GCA 3108B.
But if we were to deny it, I mean, he'd be right back in court, you know, filing another action that would that may go to the merits of the case. Wouldn't it be more prudent that we exercise our judgment to grant the interlocutory appeal and go to the merits and decide whether or not the trial court below is correct or wrong?
Perhaps if I could answer it a different way. I mean, we've seen the tactics this litigant has engaged in this matter alone, and not even including the other cases before the district court, the courts in other jurisdictions. If the court were to allow him just implicitly to take an interlocutory appeal without following the formalities, what's to stop him on the 4th motion to dismiss, the 5th motion to dismiss, and the 6th motion to dismiss? That's where I'm saying there must be some regularity, and we should be heard on the factors that would allow this court to exercise discretion.
What, didn't you do that when you answered the petition? Or you didn't, you're saying that you didn't have the opportunity to provide your comments or arguments as to whether or not the court should exercise its discretion and grant the interlocutory appeal? Or treat it as an interlocutory appeal, I should say.
Not necessarily, Your Honor, because our position was that you should not treat it as an interlocutory appeal, and that's a different position than this does not meet the merits of 3108B, and these are the reasons why.
But you did bring those matters up in your answering brief. I mean, why it doesn't meet the criteria of 3108B and should be dismissed.
If I recall, our position was just that he's not invoked that statute at all. I mean, I would argue that it wouldn't have materially advanced the litigation because all it's done is held up our motion for summary judgment for over a year. If the court, just by matter of what's proceeded recently, the court below has asked for briefing on what can it do while this appeal is pending, notwithstanding these jurisdictional questions are raised. Does it have jurisdiction to entertain a motion for summary judgment below? We have a briefing deadline on that issue on March 15th. So taking or not taking this appeal is just adding more uncertainty. And that's where that regularity that usually comes with these 3108B petitions.
But when we
is
answer
important.
the question that the court below has or does not have jurisdiction by addressing the merits, rather than waiting, denying it, going back down, the trial court issuing, assuming it has jurisdiction, because that's its ruling, and then appealing that judgment, that would just further delay whether or not the determination of whether or not the trial court has jurisdiction or not.
But then it also suggests precedent to this litigant that your fourth appeal, your fourth motion to dismiss, and an appeal from that on the same issues would be addressed the same way by this court. We'll just, even though you don't meet the formalities, we'll treat it as a discretionary appeal.
No, but because in that case, there would be a final judgment. If this court says that the trial court does have jurisdiction, it goes back down, the trial court then addresses the merits of whatever case is in front of it, and there would be a final judgment.
I understand the court's point, assuming all things were perfect, but again, there's no stopping this litigant after that precedent is set from bringing more motions to dismiss or Rule 62 memorandums or 54 memorandums.
But it won't be brought on the subject of whether the court has jurisdiction.
It may, Your Honor. You'll note in the record before you, this is the third motion to dismiss where these issues were addressed by the trial court in each motion over and over again, which is why she relied on the law of the case and not an up and down
Yeah, but
jurisdictional
we haven't
analysis.
weighed in. We haven't determined the finality of that issue. And if we do, then that is going to be the law of the case.
That's correct, Your Honor. Again, in a perfect world, I probably would concede the point, but in this case, as this litigant has brought it before and the tactics this litigant has engaged in, I just don't think there would be any true finality, especially if the precedent is set that he need not meet the formalities required of this court for other parties. It would disadvantage, would we, the plaintiff and the defendant appellees be entitled to the same consideration without meeting the requirements? We're disadvantaged just by virtue of we didn't bring as many appeals in as short an amount of time as he did.
You bring up the law of the case, and the court found that Dr. Phillips' status as a resident of Guam was the law of the case, relying on the district court's holding. Is the Superior Court bound by the findings of the district court in an order of remand?
Our position would be yes, Your Honor. And that's because if you consider how removal and remand work, it's not always the case that the court takes it back on the first motion at the district court. I can think of situations where federal statutes might be initially invoked in a complaint, discovery proceeds, and then we find out the federal statute may not apply and federal question jurisdiction is lost. But by that time, the court has ruled on issues like its subject matter jurisdiction to hear a claim, personal jurisdiction over the parties by virtue of service under federal law. But then it gets remanded to a state court, in this case, the Superior Court of Guam. Those issues, unless they were clearly erroneous, really need not be revisited. And that's the purpose of this court's holding in Kualde in the law of the case doctrine, is unless you can show some reason to revisit these issues, the court needs to preserve its precious resources and limited docket space for matters that need be revisited. So there is no reason, and Dr. Phillips has cited no authority why the court shouldn't have relied on that. The domicile inquiry that the court engaged in mirrors very closely the residency and presumptions that would appear in the Guam court. And I note, Your Honor, even if the court were to disregard the district court's findings, the Superior Court was very careful to say, but even by Dr. Phillips' own admission in an attachment to his answer, he touts his Guam residency in trying to defeat jurisdiction in a North Carolina court. And if I could just, the Superior Court was kind in that regard, because if you were actually to look at the record that's before this court, I'd point to the following pages in our excerpts of record. That's 7, 12, 28, 77 and 80, 89, 102, and 98. Each of these pages of documents are pleadings filed by Dr. Phillips, where he says some variation of, for diversity jurisdiction purposes, I'm a resident of Guam, the LLC is not.
So your argument is the trial court got it all correct on the issue of jurisdiction. Is that correct?
On the issue of subject matter jurisdiction, there is a clear statutory basis. On the alternative grounds the Superior Court ruled, each of those could be, if this court were to reach the merits, could be adopted by this court to affirm that decision. Absolutely, Your Honor.
So why shouldn't that be the interest of your client? And I don't understand why you're arguing against it.
It's not that we're arguing against it, Your Honor. It's just, we do not want a precedent to be set that this litigant does not have to follow the same rules as every other litigant. We expect some regularity in the matters that are brought before this court and the procedure used to get before this court. And if there is no regularity, then ultimately two things are going to happen. One, you're going to see more appeals from this litigant.
Do you think the provisions of GRAP Rule 4.2 with the requirement of a petition are jurisdictional?
I do think they are jurisdictional, perhaps not in a separate document that is a petition, but at least addressing the issues that need to be addressed in a discretionary appeal so that this court can exercise its discretion in an informed manner and not have to shoot blind and say, well, you'll get a final judgment anyway, so we might as well just do this. Again, it opens the floodgates. Pro se litigants would flood this court, and this court would set a precedent that you don't really need to follow that rule or give us the factors. We'll just take it because it may move things along. We're not sure in each case how each litigant will treat it, but we'll entertain you, bring it on up to the Supreme Court. It's kind of open season would be our position. And my second point is that really it would disadvantage parties represented by counsel because we'd be held to a different standard. It's one thing to say, we'll give inferences in favor of a pro se litigant. We can, if there's, they mistype something or the format's incorrect, we still want to see their arguments and let us draw what their argument is, what we can grasp from that. It's a completely different thing to expand this court's jurisdiction and express requirements in Guam law just because the litigant is pro se. It disadvantages represented parties, and maybe more pro se litigants need to come before this court to just kind of go in an ad hoc fashion without the rules applying in discretionary appeals. That's what's at stake here, Your Honor. If I could just contextualize.
Let me just ask you one more question. Did the Superior Court take any substantive action during the pendency of the federal appeals?
You're referring to the Ninth Circuit appeal?
Yeah.
Not that I recall, Your Honor. In fact, the Superior Court asked for updates from the PACER website as to what was going on in the Ninth Circuit. We cited to two authorities in our brief, Cnty and DiMartini, which very clearly show that the Ninth Circuit, this wasn't new law, it's not uncharted territory. If there is a remand on jurisdictional grounds, that's not reviewable. So you can go start moving in the Superior Court or the state court. Here, I think the Superior Court was rightly cautious because this court's authorities and jurisprudences, as was mentioned during Dr. Phillips' presentation, give the litigant their day in court. So I'm not as familiar with that part of the record, but if I recall, the court was looking for updates from the Ninth Circuit, and we did turn in and submit for filing the unpublished memorandum opinion. I would have to check if the court would like me to provide an update in writing.
It's fine, thank you.
Your Honor, if I could just contextualize very quickly. In January 2019, PCMH domesticated a foreign judgment against Dr. Phillips. That's clear in the record. What's not so clear is RSA-Tumon. You've heard Dr. Phillips today say it's just a name. In fact, it's not. We filed a corporate disclosure statement and that we're required to file. RSA-Tumon is a Delaware LLC registered to do business in Guam. It has 3 members, one of the minority members being Dr. Phillips. It provides outpatient dialysis services at a clinic, and Dr. Phillips is a medical provider. When PCMH attempted to enforce its judgment by writ of execution, it executed on Dr. Phillips' 5% share in the clinic and the distributions flowing therefrom. This was in November 2019. After some litigation about how the judgment was being enforced and the attempts to reach the distributions and the ownership interest, RSA initiated this action in July 2020, a complaint for interpleader and injunctive relief. That's 4 years ago, just to give the court an idea of how long this has trudged on. We first dealt with an unsuccessful removal or transfer, as Dr. Phillips captioned it, to the district court. The district court remanded and said there is no complete diversity, there's no federal question, and there was no objective basis for removal. We will award RSA-Tumon attorney's fees for having to defend against this improper removal. Then he appealed to the Ninth Circuit. The Ninth Circuit summarily dismissed the appeal. It was very quick, Your Honor, and that's where I'm wondering, in that short amount of time, if there was an issue. Since then, the Superior Court has addressed 3 motions to dismiss, the most recent of which being the February 15, 2022 decision. This court's jurisprudence, Your Honors, is very clear. The party appealing, the appellant, has to demonstrate jurisdiction. Even if we go back to the statement of jurisdiction filed by Dr. Phillips, he cites the 48 USC section 1424A24. There's no such statute. There's an A2. There is no A24. A2 allows this court to establish divisions of the superior court. It is no basis for appellate jurisdiction. So even at the outset, statement of jurisdiction, there was no demonstration by the appellant that this court has jurisdiction. As the court mentioned in questioning Dr. Phillips, there's no final judgment, undisputable. 3108A is not a basis. Under 3108B, again, Your Honor, it is discretionary. I would just point to those authorities we cited that this court has said it should be a limited discretion to review, because it really should give the lower court some regularity to some of these issues that come up, not a run-of-the-mill denial of a motion to dismiss. Now, the narrow realm that this case does present potentially an issue is in the extraordinary writ context. I would just point the court really to two principal cases cited in our brief. That is the Baines decision and the Gray decision. And what's clear about the Gray decision, Your Honor, is in that case, a pro se petitioner sought a writ of prohibition. And the court, for all intents and purposes, the court summarily rejected that petition, saying you've offered only conclusory allegations as to the plainness, speediness, and adequacy of a remedy that you might have or might not have. And therefore, they still held that pro se litigant to the standards the law requires for extraordinary writ relief. And we'd ask the court to apply those same standards as applied in Gray here and deny the ability to seek extraordinary writ because it's not properly before you. Just alluding to the point I alluded to earlier. For example, had the trial court been served with the petition and briefing been invited, the trial court could have addressed the questions, right? Am I allowed to proceed notwithstanding jurisdiction is challenged? Or does this matter have to be stayed? The parties could have sought clarification of whether a stay is in place or not in a writ proceeding. Without those formalities, the request is not properly before you, and extraordinary relief really should not issue. This should be dealt with in the same manner as any other litigant bringing a writ petition, just like Gray. If the court reaches the merits, we cited to the statutory basis for injunctive relief and interpleader relief in our brief. There was a typo for the injunction. It's 7 GCA chapter 20, article 3, not chapter 3. So my apologies for that. I did catch that, but it's very clear. There was a statutory basis. The court found if RSA had properly pleaded in its complaint notice of, and given notice of facts, which if proven would entitle it to the relief, the court has subject matter jurisdiction based on those Guam statutes and rules of civil procedure. As to personal jurisdiction, the court offered you 3 alternative grounds, Your Honors. Again, the law of the case established by the district court's finding of Dr. Phillips' domicile, but also in those excerpts I've recited earlier, Dr. Phillips' clear admissions that he is a resident of Guam or had been for 10 years immediately preceding the complaint and 14 years as of last year. But again, even if we were to quibble with his arguments and say, well, you know, he may not be a resident of Guam. It's the first time he's established Florida, despite that litany of excerpts I've cited to where he said Guam. But even if that were the case, as the court correctly pointed out, he engages in business in Guam. We cited to cases in the general jurisdiction context that say that a principal place of business is enough. If you're offering your services to the residents of a forum, you're generally available in that forum. It's not random, it's not incidental. And therefore, you know, the court has general jurisdiction of your person just by virtue of your presence and offering professional services. I point to the Gillespie case, really. I mean, in that case, a California doctor was mailing medication to a Texas patient, and the court found this could be sufficient. You're engaging, you should be expected to be brought into court. As to specific jurisdiction, again, even using Dr. Phillips without citation, the answer he gave to the court, you focus on the injury. You focus on the injury. Well, we'd submit the injury is the plaintiff's injury. And here that is the potential addition of a new member into the LLC and double liability of who to pay, which is why we bring the interpleader relief. But really the context that Dr. Phillips has with Guam are that he's practicing medicine, offering services through RSA-Tumon. The income derived from that practice of medicine is then turned around at some point, some level of abstraction is given back as dividends. Those dividends are being attempted to be levied on by a judgment creditor on a Guam judgment. Specific jurisdiction, I mean, even if you just purposeful availment, he's here in Guam, he's practicing medicine through an entity, a foreign entity registered to do business in Guam. The harm at issue or the claims at issue, the interpleader claim, the injunction claim, related to the income derived by that LLC and his eventual distribution. The reasonableness, I think, there are lots of factors elucidated in the case law, but if I could just distill it down to something very simple, Your Honors, the reasonableness is that no one needs to go anywhere else to try and enforce or address the enforcement procedure for a Superior Court of Guam judgment against a judgment debtor. And really, that's really what it comes down to. Whether he's a non-resident or a resident, there is a Guam judgment against him. And what court is the appropriate court, and what court can exercise jurisdiction over his person to address a third party's claims related to attempts to satisfy that judgment with property held by that third party.
So let me see if I understand that, counsel. So if the court was inclined to grant the case as an interlocutory appeal, it's your position that your client should be allowed to file briefs addressing the merits of the case? Or can we just go directly based on the current pleadings?
I think generally a respondent or an appellee should be allowed to respond to the merits of a petition for interlocutory appeal. That was not allowed here. Notwithstanding, I think that, it's very clear where the Superior Court was correct on the merits. There has to be regularity.
So you feel that if we exercise our discretion, that would be imprudent because it would open the floodgates for pro se litigants to file interlocutory appeals as a matter of course, and that we wouldn't have the ability to exercise our discretion because of the limited granting in this case, that it may help advance the termination of the litigation?
I do think it would set a precedent that is not consistent, for example, with this court's decision in Mariama, where it said that a litigant failing to petition and seek interlocutory appeal waives the right to do so. So
Yeah, but in that case, there was clearly the three-factor test of an interlocutory appeal was not met.
and we'd submit, had we been heard, it would not be met in this case either. And another.
Mr. Brennan, I don't understand why you say you weren't heard. You had every opportunity to submit briefing on that issue.
Understood, Your Honor, but again, the onus is not on the appellee to demonstrate jurisdiction. I mean, you've not followed the proper procedure to bring an interlocutory appeal. And are we expecting more of just the represented parties to meet the requirements of the statute and properly invoke or inform this court of why or why not discretion is appropriate? That's the difficulty I'm having, is that I think.
No, but you've weighed in of why we shouldn't grant interlocutory appeal. That's different from saying you weren't given the opportunity to do so.
I think that's correct. And that I guess I'm trying to make that distinction, is that I think, litigants should be heard and there should be some regularity to how these petitions are brought before the court. Otherwise.
That's a given. I mean, we fully understand, but we also have certain unique circumstances here that we consider in the exercise of our discretion. We have a pro se litigant who is not shy about filing lawsuits, appeals, all over the place. And my specific interest is that we have limited resources here at our local judiciary. And if cutting to the chase and getting to the question of whether or not the Superior Court has jurisdiction or not at an early stage, rather than waiting until there is a final judgment, that may be in the interest of the litigation.
Again, Your Honor, but I would just point to how this matter proceeded. I mean, even if you look and you found the merits today where that Dr. Phillips is a Guam resident. I mean, that's what the district court found in March 2021, but then he suddenly changed residence to Florida. And then the question became a little bit different.
That issue would be done with in this particular case, in the case below that you are engaged in.
I guess I would just disagree, because that issue, there's no guarantee that the issue would come about in the same way.
But there would be consequences to Dr. Phillips himself personally should he defy the judgment, the decision of this court, if we were to say that the lower court has jurisdiction, it issue a final opinion, and then he goes downstairs and then files another motion questioning jurisdiction, there's going to be personal consequences to Dr. Phillips.
Well, I should hope so, Your Honor, but again, this is the third
Well,
motion.
you are arguing against it, that that should not be the case.
It's not that our position is necessarily against this court reaching the merits. It's that in this case and how this is brought before you, this is the third motion to dismiss. One would also think that after the first motion to dismiss in the Superior Court finding subject matter and personal jurisdiction and dispensing with arguments about Rule 54 of North Carolina's Rules of Civil Procedure and the time to get a default judgment in North Carolina and the fraud upon the court and the fraud committed by the defendants, you'd think these arguments would be rejected out of turn. But here we are, we filed this matter.
This is our first opportunity to address it. I mean, the trial court clearly had the opportunities and properly disposed of it.
I agree with that. But again, I mean, this appeal was filed in March of 2022, the notice of appeal. It's now March 1st, 2023. And if the court's going to be uncertain about its ability to act going forward and the appeals take even half the time, it wouldn't advance a resolution to this litigation. I just submit that it would set a precedent that this litigant can do as he pleases and come up here as he pleases. I know this.
And you feel that we would be compelled to exercise our discretion only that we would grant all future interlocutory appeals by this litigant?
I think you'd be setting a precedent that he could try, and it would raise enough of a question before the Superior Court about their jurisdiction to act while notices of appeals, no matter how deficient, are brought before this court. How often, how substantive, how different or similar the issues are, that would still require briefing on my client's part to come up and get this court to act. And there's no telling how much time that could take, even if it took half the time of this appeal. Does that mean RSA's February and March 2022 motion for summary judgment should wait another 6 months?
I think you're shortchanging this court's ability to exercise its discretion on a case-by-case basis by saying that we would be bound in all future cases to rule in this way just because we see the factors in this case that we may decide otherwise.
Your Honor, co-counsel, but counsel for the defendant appellee did request 3 minutes. If I could respond to that point and close. I don't think we are not shortchanging this court's ability to exercise discretion. We're just asking that the court do so in an informed way, and how it has done it with other, be they represented or pro se litigants in the past, and not set up a new Dr. Sharif Phillips rule, because that's really what would happen, Your Honor. And so while it's not trying to control or limit the court's discretion, it is just trying to keep some regularity to the process so that litigants know if there's a petition for an interlock appeal, it will proceed in X manner. We'll address the merits first of the interlocutory request for relief, and then potentially reach the merits. Not it all has to be addressed up front, just in case the Supreme Court decides to address an issue or not. For the reasons I stated, I know I zoomed through the personal jurisdiction issue. It seems clear to us this court lacks jurisdiction. No final judgment. We don't believe the procedure for an interlock was followed, notwithstanding the court may read my brief as informing it of some of the factors. And really, there's no proper request for extraordinary relief pending before this court. On that basis, the court could summarily deny on jurisdictional grounds. If the court decides to reach the merits on either an interlock or perhaps on a writ petition, we think the Superior Court judgment was valid. Dr. Phillips has offered no basis to disturb the findings of the Superior Court, and it should be affirmed. With that, thank you, Your Honor.
Thank you, Mr. Brennan. Mr. Berman? He saved you 1.5 minutes. We'll let you have your 3 minutes, Mr. Berman.
Thank you very much, Your Honor. May it please the court, Daniel Romer on behalf of Pitt County Memorial Hospital, Inc. I'm going to confine what I have to say to just what I heard today, just in this oral argument, because I think that tells this court enough of what to do with this appellant. To begin, Dr. Phillips is a vexatious litigant. as this court has hinted before in the other 4 appeal cases that have come to it, and probably will refer to it in the next 2 that are already before you, making 6 appeals to the Supreme Court of Guam. This case should be a warning that the 5th, 6th, 7th, 8th appeal that we can expect will be treated as a vexatious litigant. The questions of Justice Carbolito were revealing. He asked, the Ninth Circuit dismissed your appeal. Isn't that final? The answer, equally telling. I filed another appeal. That summarizes it all. Long as he believes another appeal will stay this case or lose jurisdiction in a trial court, another appeal will follow in every court between here and down the street in Soledad Avenue. Second, Justice Carbolito asked, do you feel by filing this judgment, it'll go away? Non-responsive answer. If they stop, then I pay fees, they don't deserve it. That's non-responsive. It's a revenge type comment. Third question, Justice Carbolito, that I picked out. The judgment Superior Court of Guam is final. Response, it is not final. Your Honors, this is the time and place to tell him it is final. There is no more appeal that can be taken. Another question from Justice Carbolito, what's your end goal? Filing another
So
lawsuit?
then you
or the appeal?
disagree with Mr. Brennan that we shouldn't resolve this if we can.
I'm sorry.
Then you disagree with Mr. Brennan that we should resolve this if possible. Exercise our discretion.
Thank you, Your Honor. I disagree with Mr. Brennan in multiple ways, but that is one. Thank you. Going on to Chief Justice's question, this is a claim about your business that is in Guam. And he half responded that they offered me 5%, but what he didn't say is, I accepted the 5%. He made his deal to be in Guam. He wants Guam. He lives Guam. He practices medicine in Guam. He's making money substantially all in Guam that we know. Last, Your Honor, Chief Justice, you asked him to try to confine himself and stay away from the North Carolina issue of a judgment. He went straight for it on his opening argument. He said the North Carolina is a default judgment. No, stop that attack. Doesn't belong here, as Your Honors have already pointed out. In closing, Your Honor, I am requesting a determination of vexatious litigant. I'm asking for, among other sanctions, a pre-filing sanction that stops counsel such as my co-counsel, not my co-counsel, co-defendant's counsel, Mr. Brennan and myself from having to file an opposition to every paper dropped into the clerk of court office. The drip, 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 and the plan to keep this in appeal stages must be thwarted. And with that, Your Honors, we submit on the briefs. Thank you.
Thank you, Mr. Berman. Dr. Phillips, you have, I think, 13 minutes remaining.
I heard it all today, and especially from Berman. Basically, he filed almost 75 motion and stuff, and he keep filing, and I have to respond to him. And even he filing a subpoena, and one after the other, even for the Guam Medical Board, and I file, and even the IRS taxes and everything. Basically, if we're looking for the Guam order, I transfer the case to Guam District Court prior to the transfer, and even without the resolution of Rule 59, Guam Superior Court makes the ruling for the levy and the public auction. So where is the law here? She has no jurisdiction if the case has been transferred from Guam to the district court. She has no jurisdiction. So it is already existing. Guam order was not following the law, all the requirement of the law. If we're looking about the personal jurisdiction, yes, I have to work here because they finding any place for me to elsewhere. I can go elsewhere. If I found a job in Texas or anywhere, I can go. I have tried, but they blocking me to rehire. They name me a dangerous physician because they enforce this false summary suspension for my privilege. I have very hard time to rehire. The only place accept me is Guam. You force me to be my residence, never. Even North Carolina state or federal doesn't accept doesn't accept me as a state of domicile is Guam. That's why all of the motion to transfer to the federal court has been denied. So why here been accepted? If we're looking for just if personal jurisdiction is not convincing for the court, how about the federal case? I have a due process, I have 5th and 14th amendments, and even the disputed amount over 75,000, and there is a fraud upon the court. That's why if the statute has been followed as prescribed, I'll be happy. I'm not asking for much. He keeping making title and title and title for all of this kind of stuff. He abusing me because I'm not a lawyer. I try hard and I read and I did all of my can to find all of the resources. I ran out. I spent almost $3 million for over this law. Give me one case, summary judgment all over the case from North Carolina across the board, award legal fee for summary judgment motion. How one claim never been done is punitive damage claim, never been argued to award him $500,000. What kind of law is that?
So, Mr. Phillips, Dr. Phillips, I'm sorry, you ever thought that if you spent over $3 million fighting this case, had you paid the judgment, maybe you wouldn't have spent that much?
What kind of judgment? There is no judgment at that time. After I spent $3 million, he asked me for $500,000. And he doesn't deserve it. And even he destroyed my career, my income. That's why I have to go to Guam to practice. I spent that to fighting for my life. And then after I spend all of this time, and that's why I presented by myself, I cannot afford any lawyer. I pay I'm in debts. So it doesn't make sense for me to follow the law as prescribed. I'm not asking much. I'm asking just don't all of these legal tricks. If we're looking for the history of all of the cases, it's never been dismissed related to the merit of the case. Dismissed from the statute of limitation, dismissed from the first time, like dismissal because the lawyer make a mistake that he dismissed the discrimination claim by himself. All of this is a fault. Even I sue the lawyer for malpractice, they defended by statute of limitation. So I lost everything because it's not in the merit. It is lost in the technicality and administration. All of the appeals that has been dismissed here just because I miss a margin or two space or one space, never been in the merit. Never been in the merit. Look for the merit. If the case has been transferred from Guam to district court, she doesn't have no jurisdiction. And even I filed Rule 59 within the 10 days what allow. Without all of consideration and everything, she make a decision of lobby and public auction and everything. And if I filed for post-judgment motion, she said I was untruthful for transfers. She's completely biased. That's why I go for a higher court for a reason. My aim for stuff, I'm looking for the finale of the 9th Circuit. That's why I consolidate and transfer everything to the 9th Circuit, the related case and everything. And the opening briefing has been filed. So my aim, just put everything stay, see what's the decision of the 9th Circuit. This is a finale. That I was requesting that because we're taking all of this hassle and wasting of the money of the jurisdiction, put everything in hold and stay. I filed for record filled in Dr. Line. Anyway, after the state and everything done, see what's going on with all of this kind of stuff.
If the 9th Circuit rules against you, will it then be over?
Yes, for sure it's going to be over. I have no choice. Sure, 100%. That's the end of, that's why I ask for a finale. That's why even my stuff, I put all of the cases, the 5 of them, and all of this kind of stuff in my expert of exhibit.
So should we dismiss this appeal and then wait for the 9th Circuit?
We can put it this stay. Stay. If the 9th Circuit said I'm done, I'm done. I have to. This is a finale. Instead of waste all of this argument and writing paper and all of this kind of stuff. Let it stay until the result of the 9th Circuit. The 9th Circuit, I'm done. I cannot do anything. This God wishes.
So, Mr. Chief Justice, may I ask of councils, is there any objection to staying this and waiting, staying this appeal and waiting for the Ninth Circuit to rule? Because according to Mr. Phillips on the record, if the Ninth Circuit rules against him, that he's done. And I assume that means that you will face up to the judgment.
That's true.
And Dr. Phillips answered in the affirmative. Do you wish to consult with your clients?
Your Honor, I think, I don't know if you can hear me just without the mic, but I think,
You can raise up the microphone just to be sure.
I think if RSA could just have a position, it would just be who do we pay is really what this interpleader is all about. And a stay would not get us closer to answering that question, just in response to the court's earlier questions. It wouldn't address anything really. So if a stay is going to be sought, I'd ask that it be sought below and not necessarily on this appeal specifically.
Mr. Berman, do you have a position? I know it's caught you kind of off guard. And we understand if you want to consult with your client.
Thank you, Your Honor. If it may please the court, there's two responses. One, as personally experiencing and observing Dr. Phillips' last 3 years of 16 separate cases and appeals, I don't accept the credibility of his word that he'll stop litigating because you may stay this appeal. I'm in trial court now, right now, fighting for a JDX, fighting for an OSC, fighting for a levy enforcement, having not received a penny, despite all tools in the shed being used to collect a penny. So the word in the use stay is anathema. So if the stay is only between RSA and Dr. Phillips and all other trial court will proceed, no objection. Thank you.
All right, thank you, Mr. Berman.
Excuse me, Your Honor. If I file for Rackerfeld and Dr. Line, this automatic stay, I already filed for it. And he doesn't believe in this federal court statute, this automatic stay. Even his legal fee has been denied by the Ninth Circuit. Whatever he filed in all of this motion has been denied.
But Dr. Phillips, I guess I need to ask, you filed a petition with the US Supreme Court.
Yes, I
It was
did.
denied.
It's not denied. It's denied. The first one is when I filed for in the Fourth Circuit and everything get accepted, but I missed the due date. I missed the due date.
So you didn't file?
I
A
missed.
writ from the
I
Ninth
missed
Circuit
when
decision?
they told me I have to have a special format booklet kind of stuff. I give him 7 books. It's supposed to be 41 book. So they said me you're not following the rule and regulation. And even I got a phone call from the clerk. They tell me wait, I accepted, but you don't file the 41 book.
So your petition to the US Supreme Court was from
Was
the
denied in
North
administrative.
Carolina case,
For
not
the North-
from the Guam case?
Not on the Guam. No, in Guam case, it doesn't go through, no,
Because you were untimely in filing that one, right?
exactly.
Yeah.
So if I file for that's last question, if I file for already Rackerfeld, then I'm entitled for automatic stay. That's a law.
All right, anything else, Dr. Phillips?
No, I appreciate it, Your Honor.
All right, thank you. The court will take the matter under advisement and will issue an opinion or an order. And the court will now stand adjourned.
Thank you.